Dear professional colleagues, welcome to much awaited first edition of GST Weekly Update. In this weekly update, we will consider notification, clarification and circular issued by department during this week. And we will also discuss few major legal cases decided during this period. Before we end, we will consider the queries, issues or concerns received by us for this period. So let's begin with the notifications and circulars clarification issued in this week. So on 3rd of January 2024, Department issued a notification number 001/2024 Central Tax Rate, in which it was decided that LPG for non-automotive purposes will have a 2.5% CGST rate, which means effective rate will be 5%. And this LPG for non-automotive purposes need to be conforming to standard IS 4576. The effective date of this notification and the rate of second notification of importance is notification number 04/2004 Central Tax, which was issued on January 5, 2024. Through this notification, CBIC has declared or notified a new special procedure for registration and special monthly return by manufacturers of tobacco, pan masala and similar items. These requirements in this notification are: number one, all these manufacturers of tobacco, pan masala need to file the detail of their packaging machines in the GSTR SRM1 form within 30 days of effective of this notification. Second, monthly return needs to be filed in GSTR SRM2 within 10th day of the next preceding month. A chartered engineer certificate need to be filed in SRM3 form on electronic portal accordingly. Now let's discuss important case laws decided during the period. In case of Vijay Kumar versus Commissioner of GST, Bangalore, reported in 2024 edition of NTN volume 84 on page number 7, regarding cancellation of registration. No reply was filed by the petitioner, but the cancellation order mentioned that reply to be non-satisfactory. So the court held no, despite recording of the petitioner has not responded to the so-called notice dated 29th March 2022. The second respondent had recorded on opinion based on Ali's examination of reply and submission made opinion based on that. So court decided that no mind was applied in this case, and the case was decided in favor of SSC. In second case, Ankit Kamboj versus State of UP and another, reported in NTN 2024 volume 84 at page number 9. Order detaining the goods cannot be sustained when it was not passed within 7 days of service of notice. This was to be noted in this case. The goods under consideration was a chassis, not the goods in the vehicle, and there was no goods in the vehicle, and the vehicle was being driven from one place to another. In light of above, because this order was not passed within 7 days, it was decided that entire proceeding initiated under section 129 of the Act was invalid. Same was quashed. The department has to return the chassis, which was bus, to the petitioner within 4 days from the date. In another order of Brijesh Kumar Singh versus State of UP which was reported in 2024 NTN volume 84 at page number 39. Personal hearing had to be allowed to the practitioner before passing adverse assessment order, even though if the petitioner did not opt for the same. So court held the justice of natural justice that in all the cases, if an adverse order need to be passed, the personal hearing is must to be given even if SSC has not passed for the same hearing. And similarly, the order was decided in this case. In another case of Preca Solution versus Assistant Commissioner reported in 2024 NTN version 84, 87 pages, assessment order passed under section 74 without providing proper opportunity of hearing to the petitioner cannot be legally sustained. Subsection 4 of section 75 of the Act 2017 mandate that the opportunity of hearing shall be granted where a request is received in writing from the person chargeable with the tax or penalty or any other adverse decisions is contemplated against such person. This was decided in the court accordingly, and the writ petition was allowed, set aside the order under subject dated 18th November 22 passed by the first respondent. However, the order will not preclude the authorities from passing the order afresh after hearing the petition. So this was decided by the court that authorities should allow a hearing and should pass a fresh order. In another case of Kesoram Industries versus Commissioner 2024 NTN version 84 at page number 20, GST's authorities were not allowed legally justifying in issuing garnishing proceedings to bank for recovery of interest for delayed payment of tax without determining the payable amount of interest and without providing an opportunity to the SSC to submit his reply to the notice, and only thereafter the authority shall proceed further by taking into account that reply and explanation submitted by the SSC. In case of Vijay Jindal Cocoa Private Limited versus Union of India, NTN 2024 volume 84 page number 4, it was decided that petitioner is not entitled to payment of interest on late disbursal of budgetary support amount, as department has all the valid reasons for the delay. And this was decided that he has right to get the benefit of budgetary support, but he cannot claim interest on against the valid reasons of delay. In another case of Jain Brothers versus Union of India and others, in which it was decided that section 16 subsection 4 of CGST Act is in not violation of Article 14, Article 19, 1G and 300A of the Constitution of India. As we all know that section 16 subsection 4 relates to ITC, and it was decided in the order that ITC is in the nature of benefit or concession extended to the dealer, and it can be availed by the beneficiary as per the scheme of the statute and subject to the fulfillment of certain conditions laid down under section 16 subsection 4 of CGST Act. In that view of the matter, the section 16 subsection 4 cannot be held in violation of Article 14 of the Constitution. A very interesting proposition was also discussed in the court that SSC and appellate person in this case is the firm and not the individual who is the citizen of India. And when analyzing Article 19, court said that the benefit of Article 19 is allowed to the citizen of India, and as in this case, the person who came to the court for request and looking at his writ petition under Article 226 and 227 of the Constitution of India, it has been filed by any citizen in individual capacity. Rather, it has been filed by the proprietorship firm, namely Messrs. Jain Brothers through its proprietor Mr. Amit Jain. Under Article 19(1)(g) of the Constitution, it is available to the citizen in order to claim the protection under this article. The person coming to the court must be a citizen, and in this case, this was not a citizen but a proprietary firm. So this was decided that Section 16 subsection 4 is not in violation of Article 14, 19 and 300A of the Constitution of India. In another case of Jitendra Kumar versus State of UP reported in NTN 2024 volume 84 at page number 18, revenue cannot later on change its stand regarding the ground on which the goods were originally detained. In this case, it was clear that the detention was made on the ground that the goods were not accompanied by the valid documents, whereas the so-called notice was issued. When so-called notice was issued, there is no whisper of any invalid documentation whatsoever. In fact, the court observed that stand was completely changed in the SCN. This was decided. The writ petition was allowed to the petitioner. The revenue was directed to release the goods and the vehicle of the petitioner within the period of 7 days. In another case of Emil and another versus State of UP, reported in NTN 2024 volume 84 at page 1, impugned order need no interference of this court once a specific finding has been recorded by both the authorities to the extent that the selling dealer was no existence at the place where this firm is said to be registered, and only through the e-way bills. The e-way bill was generated, goods were being sent from some other location which was disclosed on e-way bill, and ITC was to be claimed. And the court decided that court don't want to be interfering in this case and allowed authorities to go ahead with their proceedings. In another case of India Herbal Stores versus Union of India, court decided that amendment to the Rule 84 Sub-Rule 4C of the CGST Rule 2027, which is relating to computation of export turnover, has no retrospective effect in its nature. And while deciding this case, court referred to the case of Tongo Imagine India versus Union of India, decided by Karnataka High Court. In another case of Sandeep Kumar versus Deputy Commissioner, reported in NTN volume 84 at page number 89, it was decided that penalty cannot be levied under section 129 for the goods found in godown and not in transit. In this interesting case, the department argued that at one place argued that the goods were in the godown without proper documentation, and at the same moment they tried to build a case where the goods were found without documents and were in transit. So court found that the goods cannot be in the godown and in transit simultaneously at the same time. So this case was allowed to the petitioner, and the court decided that penalty cannot be levied under section 29 for the goods found in godown or in transit, where the department is confused on the course of the action. In another case, Pratima Tyagi versus Commissioner of GST, reported in NTN volume 84 on page number 85, the order cancelling the registration of petitioner cannot be sustained when the so-called notice did not indicate the date and time of hearing, and order is also devoid of reasons. It appears that the order is not informed by the reason, this order has been passed in violation of the principle of natural justice, as the petitioner was not afforded any opportunity of being heard, although the SCN called upon the petitioner to appear for the personal hearing, but it did not specify the date and the time and the place for that hearing. So the decision to cancel the registration with retrospective effect must be based on some objective criteria. In this present case, the court decided that petitioner GST registrations was cancelled on account of non-filing of return for a period of 6 months, which was not an objective criteria, and court find out that no reason for cancellation of petitioner GST registration even for a period when she was filing the return is a valid reason. So the court decided that order cancelling the registration of petitioner cannot be sustained in this case. In another case of Umar Farooqi versus Superintendent, reported in NTN volume 84 at page number 46, order of cancellation of registration cannot be sustained when it was passed in pursuance of notice, providing only for 4 days time to submit the reply. It is obvious that at the time of first instance, the petitioner was granted 4 days to file the document, and in the second instance, when the petitioner appeared before the first respondent on 9th November 2022, after SOCO's notice date dated 1st of this November 2022, the petitioner is permitted time to produce the document. However, there is nothing on the record to indicate that any date was specified before which the petitioner should have furnished the document for the SOCO's notice against cancellation. The petitioner business history of over 21 years of good business practice was also not taken into consideration by department while cancelling the order. So court decided that and the court also observed that all contentions are left open to considered for the first respondent strictly in accordance with the law. So with this we end the discussion on the case laws. This being the very first episode of the weekly update, we do not have your queries or the concerns to discuss, and we hope you will reach out to us with your queries and the questions so that we can take up them in the next week. By then, keep agile and let's catch up for the most crucial update.